Good morning, everyone. My name is Andrew Holder. I'm a partner at Fisher Patterson, Saylor & Smith in Overland Park. We're here today to do training on discrimination and harassment in the workplace. I've been with the Fire District for about 2 years now, and I'm excited to be here. All right, so what I'm not here today to do is ask for anyone's retirement from comedy. What I am here today to do is make sure that people understand the laws that apply, the policies of the fire district that apply, and what those expectations, what the expectations are for you in terms of your behavior and what you can expect of your coworkers. So the disclaimer at the start of this, the idea here behind this presentation is that this is a general summary of the state and federal laws that apply. The laws are a living, breathing thing, so it's a moving target, meaning I've done my best to provide you with up-to-date materials, but the law is always changing. This is not legal advice. If you've got specific questions about a scenario or how something should apply to you, contact legal counsel. So the objectives of the presentation today, number one, we're going to identify the different types of laws that apply in the context of discrimination and retaliation. Number two, we're going to make sure you know how the policies the fire district apply for you. And number three, we're going to make sure that you understand what you can do if you run into a problem. So as an overview, when we talk about different laws that might apply, the things we're going to talk about today will be discrimination laws, harassment laws, retaliation. We'll spend a little bit of time talking about the FMLA and the ADA, and then we'll wrap up by talking about litigation as a whole so that you can understand what the process for filing and being involved in an employment discrimination lawsuit looks like. So you can understand why that's such a big deal and why that's something that we want to avoid. So when we talk about employment laws, there are a variety of different areas that can apply. The primary one that we're going to talk about today is Title VII, although we'll spend some time talking about other laws that kind of fill in the gaps where Title VII left things out. So we start that discussion by talking about the protected classes, and when we do that, we're looking at the actual text of Title VII. I'm not going to read the whole thing to you, but in short summary, what Title VII says is that it's unlawful for an employer to discriminate against an employee because of the employee's race, color, religion, sex, or national origin. So when we talk about protected classes under Title VII, the classes that we're talking about are race, color, religion, sex, national origin. I'm not going to spend a lot of time talking about every single one of those because I think for the most part those protected classes are fairly self-explanatory. But I do want to spend a little time talking about sex discrimination because there are a couple key areas that I think may not be so self-evident. The first has to do with sexual orientation. Title VII doesn't define the term sex, so for a long time there was ambiguity or some level of uncertainty among the courts about whether sex discrimination included protections for discrimination on the basis of sexual orientation or sexual identity. In 2020, the Supreme Court came out with a decision called Bostock versus Clayton County, and what that decision said is that discriminating on the basis of sexual orientation or on the basis of sexual identity is sex discrimination. So that clarified the issue as far as Title VII goes. When we talk about Kansas state law, the term sex is not defined under the Kansas Act Against Discrimination either, and there have been no Kansas appellate courts that have had the opportunity to rule on whether Bostock would apply to the Kansas Act Against Discrimination, and we'll talk a little bit later on about why that is. But the takeaway as far as Kansas law goes is that Kansas courts typically treat the Kansas state statute identically to Title VII, so the assumption is that they would apply Bostock the same way. So when we talk about sex discrimination, I think the key takeaway here is that discriminating against someone because of sexual identity or orientation is prohibited. When we talk about sex discrimination, the other thing worth pointing out is that it also includes discrimination on the basis of pregnancy, on the basis of childbirth or associated medical complications, and it applies to the entire gamut of employment decisions, not just termination, meaning just disparate pay, differing treatment or enforcement of policies, all of those things. When we go through Title VII and the protected classes there, age isn't listed under Title VII. Age gets its own special protections in a totally separate statute, and that's the Age Discrimination in Employment Act. The the protected class under federal law for age is individuals who are 40 years or older. That's also true under Kansas state law, and those are both different than, for example, the state of Missouri, which has an age cap of 75 years on it. The Kansas state statute, the federal statute don't include that. So although Title VII doesn't protect people on the basis of age, it does get its own separate act. The next thing to talk about, what I pulled here is the administrative policy for the fire district, and it's policy 99.02. This is the equal employment policy, and the basic idea behind this policy is that the fire district does not discriminate against people on the basis of, and then it lists a whole variety of different protected classes under the policy. We've talked about the Title VII protected classes and the ADEA. I think that the key takeaway here is that when you look at this, there's obviously more protected classes under the fire district's policy than there are under these statutes. So the takeaway is make sure you read the policy and are familiar with all the different classes that it applies to. So let's talk about how the Kansas Act Against Discrimination and Title VII apply. So we start with the text of the statute again. And the prohibition, meaning that who it's saying can't discriminate, is employers. And so the definition of employer under Title VII is on this slide here. And I think the takeaway is Title VII applies to employers that employ 15 or more employees. When you look at the Kansas state statute, the definition is similar, but there's a lower number of employees to qualify. Under Kansas state law, you just have to have 4 employees. So there can be employers that would only be subject to the Kansas Act Against Discrimination but not Title VII, or there can be employers that are subject to both. And the takeaway for all of you is that the fire district is an employer under both of those statutes. When we talk about who is and isn't an employer, the purpose of this slide is simply to explain that the employer is the fire district. It's not any subpart or division or sub-agency. The ultimate takeaway here is the employer is the fire district itself.
People say, I am the best boss. They go, God, we've never worked in a place like this before. You're hilarious. And you get the best out of us. I think that pretty much sums it up. I found it at Spencer Gifts.
Okay, so the next question is, the fire district is an employer. Is the boss, is your supervisor or your coworkers employers? And what the 10th Circuit has told us is under Title VII, the employer is the fire district and not the supervisor and not the coworker. We're going to talk about some other anti-discrimination statutes here, but what the courts have said is that's also true under the ADA. The courts have not ruled about whether a supervisor or coworker can be sued under the ADEA, but the assumption is that they cannot for the same reasons that you can under Title VII. When you look at the Kansas state statute, I think the answer is a little murkier because the definition of employer under the Kansas state statute includes any person directly acting in the interests of an employer. Federal courts have touched on this and generally tend to apply the Kansas state statute the same as the federal ones. So there are some decisions that say a coworker or a supervisor can't be sued under the Kansas Act, but it's also true that that specific language was included in the Missouri statute that prohibits discrimination, and Missouri courts interpreted that language to allow supervisory liability claims. So I think that under Kansas law, the answer to the question is a little more ambiguous. When we talk about discrimination, we're really talking about two different types of things, disparate treatment and disparate impact. Disparate treatment is the one that you're all probably more familiar with. That's the concept of treating somebody differently because they're a member of a protected class. So disparate treatment is intentional conduct. Disparate impact, it doesn't have to be intentional. A disparate impact is a facially neutral policy or action that may not have a discriminatory intent behind it, but in practice, if the policy, even if it is facially neutral, if it in operation results in a protected class getting disparate treatment, it still can result in discrimination. For the most part, because disparate treatment claims are intentional and those are the ones that can be controlled and prevented, that's what we're going to focus on talking about today. But this chart, I think, illustrates the difference. And the key point here is that for disparate impact claims, because no intent is required, I think that it underscores the importance of just making sure that when decisions are being made, that you're trying to think through the consequences of those decisions, even if to make sure that in practice they're not having a discriminatory impact on someone. When we talk about disparate treatment claims, one of the key focuses and one of the terms that we're going to talk a lot about is adverse employment actions. And what courts have told us is that an adverse employment action is an action that constitutes a significant change in employment status or benefits. And the key word there is significant. When we talk about what is an adverse employment action, courts have said we're not really interested in talking about things that don't have a significant change, alterations to where somebody's desk is located, changes in parking spot. Those are the kind of things that even if an employee may not like them, are really not what we're talking about when we're talking about adverse employment actions. Things that would qualify as adverse, the most obvious one is a termination. Other things that clearly constitute adverse employment actions would be decisions to hire somebody or not to hire somebody, decisions about how somebody's going to be paid, decisions about how discipline will be implemented or not implemented to an employee. And so those are all the types of things when we talk about disparate treatment, that's what we're talking about. Shifting gears to talk about harassment. I think this chart is helpful to illustrate where harassment falls in the spectrum here. So specifically, sexual harassment is a type of harassment, and harassment is a subset of discrimination. So when we go through and talk about the different types of sexual harassment that can exist, we're still ultimately talking about discrimination. So sexual harassment is unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. The key takeaway when we talk about unwelcome conduct is that it's not solicited, incited, or wanted, and ultimately it's the perception and the reaction of the victim that matters. What I've pulled up here is Fire District Policy 99.02. And this policy sets forth the fire district's definition of sexual harassment. That matches the federal definition. So we're not going to spend a lot of time going through that again, but the policy also indicates examples of things that can be considered sexual harassment, and that includes actions, words, jokes, or comments. And you'll notice that the policy is not limited just to sexual harassment, because harassment can be on the basis of any protected characteristic. It's not just limited to sex. So when we talk about different types of sexual harassment that can exist, one type is quid pro quo, and quid pro quo is simply Latin for this for that. And the concept here is that unwelcome requests for sexual advances or favors are tied to an employment decision of some kind, whether it's the decision to hire, the decision to promote, a decision to provide a raise or something. To the extent that an employment decision is tied either explicitly or explicitly to a request for some sort of sexual favor or sexual advance, that's quid pro quo sexual harassment. The second type is one that you're probably more familiar with. That's hostile work environment. And when we talk about hostile work environment, what we're talking about is an environment that is permeated by discrimination. And courts have told us that to ultimately poison the entire workplace environment, conduct has to be severe or pervasive. And that's a high bar to meet. Courts are ultimately not interested in weighing into every minor employment dispute that arises. We're really looking for conduct that's got to meet a certain threshold. And so the things that courts look at are the severity of the conduct, whether it's physical in nature, or whether it's just verbal, whether the conduct interferes with the ability to work, and how frequently it occurs. So those are the things that the courts really look at. And ultimately, when we're evaluating whether a hostile work environment exists, courts view that under both a subjective and objective standard, meaning that we look at, number one, was the person that's raising the complaints, subjectively, were they personally offended by it? Number two, would a reasonable person have found the environment to be hostile and abusive? And the reason that courts look at that from both perspectives to ensure that we're at a scenario where we're really only evaluating things that everyone could agree rise to that level. The other side of the coin is obnoxious behavior, and like I mentioned, when we talk about creating a hostile work environment, we're not really talking about conduct that's simply obnoxious or immature. the courts have tried in interpreting these statutes to come up with a system that makes sense and that's feasible and practical, and ultimately I think there's a recognition that there can never be a guarantee that you're never going to hear a joke you didn't think was funny at work, or that you're never going to encounter somebody that's rude or obnoxious. That's really not what we're talking about, because that conduct doesn't meet the bar of being severe or pervasive. I want to walk through two case examples here that I think illustrate a couple of the points here. The first one is Hairston versus Warmuth. And this is a case where a female employee complained that on one occasion her supervisor commented to the rest of her coworkers that he thought she was pretty and she had a nice booty. On another occasion, he told her she couldn't leave for the day until she gave him a hug. And then on a third occasion, he dropped a salt shaker down her shirt at an office party on purpose. And what the court said is none of that is good behavior. None of that is behavior that we want to encourage. But when we're talking about severe or pervasive, these three isolated incidents aren't enough to show that the entire workplace has been permeated or poisoned by sexual harassment. The flip side of that coin is this case, which is Mooring versus Arkansas Department of Corrections. The basic fact pattern here is a female subordinate and male supervisor go on a work trip overnight. They're staying in adjoining hotel rooms. Late at night, the male supervisor knocks on the female employee's door, and she opens it, and he's in his underwear. She insists he gets dressed, and then he says he needs to come in under the guise of needing to talk about work. But then when he gets in there, he puts his hand on her leg and goes in to kiss her. And what the court told us there is that's one incident, but when we're talking about conduct, that is severe enough that this one incident is sufficient to establish a hostile work environment. So I think the key takeaway here is that when we're talking about severe or pervasive, there are a lot of times where we're talking about conduct that's happening frequently and over a lot of period of time, but one incident can be enough if it's severe enough. What I've got here is a couple real-world examples from situations I've encountered. On the left there, in the gray box, you've got the male supervisor asking the female subordinate, "Are your boobs real?" And then later on, she's asking him if he will make some Chex Mix for her, and he says, "I'll give it to you," but he sexually propositions her. This next slide is those same messages continued on the right there. And so her response to that is, "I don't think my boyfriend would like that." And he responds by saying, "Well, I'll hook you up anyway, I was just kidding." And the key takeaway here is that saying just kidding afterwards doesn't negate anything. That doesn't make any of it okay. You can't undo your offensive conduct by saying just kidding afterwards. Another type of harassment that I'm going to talk about is gender harassment. And we've spent a lot of time talking about sexual harassment, and that's conduct that is sexual in nature. Gender harassment is a bit different in the sense that we're not necessarily talking about sexual conduct so much as we're talking about conduct that would be stereotyping or that would still be harassment on the basis of gender. It's just not sexual in nature. And examples of this would be making repeated jokes about gender or making repeated derogatory comments over time if they're severe or pervasive enough. That's the kind of thing we're talking about. And so ultimately, if that is severe enough, it can rise to the level of creating a hostile work environment. And as I mentioned earlier, when we're talking about hostile work environment, it's not limited to any one protected characteristic. So an environment that's permeated by racial slurs or racial jokes can rise to that level. There's stereotypes of some sort, repeated and consistent comments about age can rise to that level to some degree. So these are all things that you need to be aware of. When we talk about derogatory or discriminatory comments, the things that the courts have focused on are, not every remark, even if somebody finds it offensive, can rise to that level. The things that the courts look at are who made the comment, is it a decision maker or is it a coworker, and what was the context of the comment, meaning was the comment made in the context of the actual employment decision that's being complained about, or was it kind of an offhanded comment unrelated to that? These are factors the courts look at when they're deciding whether this carries any relevance. So ultimately, this chart here kind of goes through the differences between harassment and discrimination. When we talk about discrimination, we're really focusing on was there an adverse employment action, and was the reason for that one of the protected classes. Harassment, we're not focused so much on the adverse employment action because ultimately the harassment itself is the adverse employment action. So those are the real differences between the two. Shifting gears now, we're going to talk about retaliation. And so what I've put up here is the text from Title VII. The concept here is that when Congress passed Title VII and sought to prohibit discrimination in the context of employment, to do that they have to learn that discrimination is going on, and the only way to do that is to ensure that employees feel safe and comfortable knowing that if they report something or they assist somebody that's reported something, that they're not going to be retaliated against for it. So the long and short of the text is that under Title VII, employees that engage in protected conduct can't be retaliated against. So examples of things that would be clearly protected under Title VII: filing a charge of discrimination, and we'll talk more about what that process looks like. Testifying in a lawsuit brought by somebody else that's filing a lawsuit asserting discrimination, or providing assistance to that person. The other one that I think it clearly falls under the protections would be reporting to your supervisor or the appropriate person in the chain of command that you're concerned you've been retaliated against, that you've been discriminated against, or that you've observed somebody else that's being discriminated against, harassed, retaliated against. Those are all things that are clearly protected under Title VII. Just as a real-world example, when we talk about providing assistance, this is a case that I was involved in, and the scenario was a former employee got fired. Through the course of discovery, we learned that a current employee of the same company was sending text messages to this person saying, hey, I know you filed this lawsuit, I'm going to be your little birdie on the inside, I can help. This is protected conduct. This is providing assistance to a discrimination claim. And so this is something that would fall under the protections of Title VII. When we talk about the key word from the text of the statute is oppose, and courts apply the dictionary definition of the word oppose there. Ultimately, we're talking about taking some sort of steps or actions to confront or contend against discrimination. And what we know is that there's no magic words that you have to say to make your conduct fall under the protections of Title VII. You don't have to literally say, I'm being discriminated against, or I saw somebody that was being discriminated against. You don't actually have to use those words, but the courts have told us you do have to at least say enough in your complaint to make sure that the employer's on notice that what you're complaining about is discrimination, even if you don't use those words. And so the example is, I'm mad I didn't get a promotion. Separate, by itself doesn't tie that to discrimination. And so that doesn't, it tells your employer you're upset, but it doesn't tell the employer that you think that there was discrimination involved. Saying, I'm upset I didn't get a promotion and somebody younger did, that'd be enough, even though you don't use the word discriminate. So the key words are just making sure that you're saying enough to tie it in some way to unlawful discrimination, not just frustrated ambition. That's the key words from the courts. We're going to shift gears and talk about a different statute. This is Kansas common law, actually, and this is a retaliation protection that exists that the courts have created. And what we know is Kansas recognizes generally employment at will, meaning, and we'll talk about what that means in a little bit, but the concept here is that Kansas courts have said you can't be retaliated against for blowing the whistle about a violation of rules, regulations, or the law pertaining to public health, safety, or the general welfare. And the key concept here is that it's got to be, the importance of what you're blowing the whistle about has to be pretty high in order for us to meet the criteria. The courts are not trying to create protections for folks that report a dress code violation, for example, because that doesn't pertain to public health, safety, or the general welfare. What we're really talking about is serious safety violations at work, illegal conduct, that kind of thing. But to the extent an employee has reported that, Kansas common law recognizes that that's protected conduct, and where that's reported to management or law enforcement, it's unlawful to retaliate against an employee for doing that. Other anti-retaliation statutes that exist, FMLA and the ADA both have retaliation statutes. We'll talk about those more in a few slides. The other one that we see a lot is workers' compensation. And the key concept here is that Kansas courts have said you can't be retaliated against for filing a workers' compensation claim. You can't be retaliated against because the employer thinks you might or probably will file a workers' comp claim. You can't be retaliated against because your spouse has filed one. And retaliation does not just mean termination. It can apply in the same context as the discrimination statutes, meaning differences in pay, punishment, other employment decisions. We're going to shift gears now and talk a little bit about the ADA. So through the first slides, we talked about the 5 classes under Title VII, and then we added a 6th for age based in the ADEA. This statute, the ADA, adds a 7th, and that's qualified individuals with a disability. The ADA prohibits employers from retaliating against employees because they've asserted their rights under the ADA. And you'll notice that both my first 2 slides here called the ADAAA. That's because the latest version is called the ADA Amendments Act. We couldn't get enough A's in there. And so that's why I'm gonna call it the ADA. It's less of a mouthful. Disability is actually a protected class under the Kansas version of Title VII, the Kansas Act Against Discrimination. So Kansas doesn't have a separate statute that applies to disability. That falls under the catch-all statute, but the ADA has its own separate statute. So the ADA defines qualified individual with disability, and that's the protected class, as an individual with a disability who, with or without reasonable accommodation, can perform the essential functions of the job. And so one note about this is that the ADA applies to individuals with a disability. It also applies to individuals who are perceived to have a disability. And what this slide talks about is that the reason that it's actually more broad than just disabilities because Congress recognized that society's accumulated myths and fears about disability and diseases make it necessary to expand the scope so that really what we're looking at is what's the employer's motive here, and we want to punish employers that are taking action because they think an employee has a disability, whether they really do have that disability or not. So that's the takeaway there. When we talk about the essential functions of a job under the ADA, the key word there is essential. We look at the job, you can look at your job description, and that may provide a good baseline for some of the important tasks that you do, but it doesn't provide everything, and so there's no hard and fast rule about where things can come from. But ultimately what we're looking at is what are the components of your job that if you stopped doing them, that job wouldn't function the same way anymore? What would happen if you weren't required to do those particular functions? Those are the ones that we consider essential. And ultimately, what the ADA requires is that employers provide a reasonable accommodation to the known physical or mental limitations of an individual with a disability, unless doing so would impose an undue hardship on business operations. And to add in there, a failure to accommodate can be considered discrimination under the ADA. So procedurally, the process for requesting an accommodation starts with the employee. The employer is not required to come forth prospectively and say, hey, I think you might need an accommodation, let's talk about that. It starts with the employee bringing to the employer's attention that they have a disability or they have a need for an accommodation to one of their job functions. There is no requirement or no magic words. You don't have to say formally, I'm formally requesting an accommodation. You can do it verbally. But again, the idea is that you have to do enough to tell the employer, I need some part of my job or some part of my equipment changed, and the reason is because of my disability. So examples here, I'm having trouble getting to work because I have to take medication in the morning for treatment I'm undergoing. Probably enough to tell the employer, here's the change I need, here's what it's related to. The other side of the coin is I need a new chair because mine makes me uncomfortable. You've identified the modification, but it isn't necessarily tied to a disability at that point. That's not sufficient probably to be a request for accommodation. So again, the key takeaway is no magic words, but enough to tell the employer that's what you're doing. After an accommodation has been requested, the next step in the process is an interactive dialogue between the employer and the employee. And the key hallmark here is just good faith. This is supposed to be a fluid process where the employer and the employee talk about what the employee's disability is, how it impacts the job, and the types of alternatives that may exist to accommodating that disability. So examples of things that might be considered a reasonable accommodation for the employer and employee to discuss during that process. Modifying the job as long as the modification isn't removing one of the essential functions. Changing your schedule, changing the equipment that you use. giving you a reasonable amount of time for leave to address the issues. And when we talk about the interactive process, there are some times where there may be one and only one accommodation that could be made, but there are a lot of times where there are a variety of different options that or routes that the employer could go down to address the employee's problem. And the ADA doesn't require the employer to pick the one the employee wants. They just have to pick one that's reasonable. So if there are multiple options, the obligation is just pick one that's reasonable. Examples of things that would not be considered a reasonable accommodation: hire somebody else to do my job for me. Give my job duties to somebody that's already here. Give me an indefinite amount of time away. Create a new job that doesn't already exist for me, or give me somebody that's currently working here's job. Those are all things that would not be considered reasonable. The other one worth talking about is excusing misconduct. And so the general rule here is that the onus is on the employee to request an accommodation before a problem arises. So if you've got an employee that's late 5 days in a row for work and the employer writes them up under their policy for being late, and then the employee says, well, wait a minute, the reason I was late all those days is because I need an accommodation for my disability, don't write me up for this. It's too late by that point because they haven't put the employer on notice ahead of time. And it's not a reasonable accommodation to ask the employer to disregard misconduct that they haven't been put on notice is caused by a disability. Shifting gears to the FMLA. FMLA stands for Family Medical Leave Act. And this is a federal act that provides some employees with up to 12 weeks of unpaid leave per year, and we'll talk about where that applies and what that means. So the FMLA applies to public agencies, and so the takeaway here is that FMLA applies to the fire district. And the grant coming from the FMLA is up to 12 weeks of unpaid leave for a qualified reason, and the reasons that you can get leave under the FMLA are for the birth of a child, for the adoption of a child, to care for the employee's own serious medical condition, or to care for an immediate family member with a serious medical condition. And the 12 weeks of leave that are granted under the FMLA can be issued either in a block of time, or they can be taken intermittently depending on what the situation and the employee require. So who's eligible to take FMLA leave? Employees that have been on the job for at least a year. Employees that haven't been on the job a year are not eligible for FMLA leave. And as I mentioned a few slides ago, the FMLA comes with anti-retaliation provisions. Employers can't retaliate against an employee because they've exercised their rights under the FMLA, and they can't interfere with or keep an employee from trying to exercise their rights under the FMLA. This is a case that I think illustrates one key takeaway, and this is a situation where an employee was approved for FMLA leave for a certain medical reason, and then the employee didn't show up to work and said it was because she had a fever and a lost voice, and those weren't the reasons that she had been approved for FMLA leave. And so this case highlights the FMLA regulations that say that the employee must specifically reference either the qualifying reason for the leave or the need for FMLA leave, and just calling in sick without giving more information is not sufficient to trigger the protections of the FMLA. So the idea here is that if you're gone from work, even if you have previously been approved for FMLA leave, unless you put the employer on notice that the reason you're gone is FMLA and not a sick day or a vacation day or something else, then the employer is not required to guess what you're going to do. So again, no magic words, but you've got to at least tell the employer enough to put them on notice that I'm going to be gone, and the reason I'm going to be gone is this excused reason under the FMLA. We're going to shift gears and talk about the policies at the fire district for reporting. I'm sorry.
Just a quick question.
Yes.
On the FMLA, is it a calendar year or when you start taking it? It counts for 12.
It's every 12 weeks per calendar year.
So if I take it in January 1, I'm good until January 1 for 12 weeks, or does it start July 1st? I go to July 1st.
It's calendar year, so you've got 12 weeks beginning each calendar year, and it renews every year.
I think what he's asking is if his FMLA starts in July, is his 12 weeks July to July or July to
December 1st,
December
December
1st?
31st.
Yeah, if you take it in July, that's for that calendar year, and then I think you've got a calendar year from the time you take it.
Right.
And I'm sorry, I was,
Right.
Just making sure.
Yes,
Yeah.
good,
Yeah.
good question, Tom.
okay, we're gonna shift gears and talk about reporting concerns. Policy 99.01.
I think we have.
Oh, I'm sorry.
No, I was gonna clarify, so if you took it, say, in October or something, end of December, you're starting over January 1st, and you fresh new 12 weeks, essentially, right?
If I'm tracking you, I think that's, so let's say as an example, you take it in October, and then you don't get another 12 weeks starting January. It's,
Yeah, you don't? Or
you do not.
Oh, okay.
October to October.
October.
Okay.
I think we just need some clarification.
Yeah, sure. Any other questions on that?
Well, what if you broke it up for the whole year then? So what if you took a few days in January, a few days in, so it just starts, then I guess if you didn't use them all, that next January it starts over again? If you started February 1st?
So the trigger date is the date that you're approved for the FMLA leave. So if it's intermittent and then you've got it for a year from the date it's approved to start taking it, and then it starts again the next year from the date that you apply for it again.
Somebody could space them out for the whole year and then start back over the whole year.
Yes. Yeah.
Yeah,
Yeah.
so Brian, once you take, so if you take that intermittently from, say, November to November, and when it restarts over, you have to requalify
Oh, so-
that next year. So you're only qualified for the 12 months, starting from the time that you start your FMLA.
Got it.
So if something comes up that you need additional, you would have to requalify for that next year.
Right. You got to apply again each year for it.
Got it.
One more question, extra quick.
Sure.
So, say
Sorry, I knew there were questions on this.
No, that's
So
good.
say you're taking, you took family baby leave, you just had a kid, you're taking off, you took off 4 weeks ago, and down the road, your wife is sick or something, are you applying it for a second time, or are you still in that 1 year window?
So you get up to 12 weeks per year, but you don't get
Like,
12
if
weeks
it's-
for each qualifying reason to the point where you could get, 48 weeks or something like
You have to
that.
actually specify, like, okay, this is kind of a new situation.
Yeah, you would, so let's say you take leave to care for a baby and you've got a month, right? And then something else happens and you've got to care for a family member. You've got 8 weeks left. And you don't get another 12 weeks for each reason. You
But then,
get,
I guess, in the eyes of your employer, you need to tell them it's something new, or you need to say, hey,
Oh.
you can take FMLA again?
yeah, so you can be approved for FMLA for any of those qualified reasons, but let's say you've got a new reason now, you've got to reapply for FMLA because the second time around when you're gone, it's not for caring for the baby anymore, it's to care for a family member. So you would apply a second time.
Within that same calendar year?
Yes. You got to
Is it
apply
always
for each.
unpaid?
I'm sorry?
Is FMLA always unpaid, or am I
Well, you,
misunderstanding?
So FMLA itself is unpaid. The fire, and I can't speak to the fire district policy, but typically there are some employers that require you, if you've got accumulated vacation or sick leave, they require you to use that. So you get paid in that sense. But let's say you burned up.
Fire within that year.
Gotcha.
So they don't have to pay you technically.
Right. So, but if you had a scenario where you'd used all your vacation days and all your sick days, and then you needed FMLA leave after that, it would be unpaid.
Got it. Okay.
So you just don't get payment from the federal government. Doesn't. Right. That's exactly right.
Got it.
Any other questions about that? And feel free as I'm going through stuff. If you've got questions about how this applies, please shout them out. So we're going to talk. This is the Administrative Policy 99.01, and this is the policy that talks about what to do if you're concerned about discrimination, either individually or on behalf of someone else. And the direction is to bring that issue to the attention of a member of the executive team or the fire district. The other important takeaway from this policy is that this makes clear discrimination is prohibited. It will subject you to discipline up to and including termination. And so if a concern about discrimination, harassment, or retaliation is reported, that concern is going to be investigated thoroughly and promptly and as confidentially as possible. And the other part of the policy is that, again, the fire district will not retaliate against employees that raise a concern or a complaint about discrimination, harassment, or retaliation. So we're going to shift gears now and talk about the lawsuit process so you can understand kind of how that works and why it's a big deal. So before a employment discrimination lawsuit can be filed, an employee has to file what's called a charge of discrimination. And that can be filed with one of two agencies or both. If it's a Title VII federal claim, it's filed with the EEOC. If it's a state law claim, it's filed with the Kansas Human Rights Commission. Or employees can file with both agencies, and the benefit of doing that is that the time period that's subject to review grows from 180 days to 300 days. So in practice, I would say that most frequently what I see is that charges are dual filed with both agencies. So after a charge is filed, and that's simply allegations made by an employer or former employee, after that happens, the EEOC or the KHRC conducts an investigation. Typically that involves the employer providing a written response to the charge, and it may involve the agency doing investigations or asking for certain documents or interviews. And once that investigation is concluded, the agency has a variety of different options. The one that we see most frequently is that they're unable to determine who's right between the two parties, and so they issue what's called a right to sue letter. And a right to sue letter is a document that the employee gets that allows them to file a lawsuit within 90 days after they receive it. So either they file that lawsuit within 90 days or the lawsuit becomes time barred. And before a lawsuit under Title VII or the KAAD can be filed, you have to have that right to sue letter. If you don't have it and you file a lawsuit, the claim will get dismissed. So when you're proving discrimination in an employment lawsuit, there are really two ways to do it. The first is direct evidence of discrimination. And this is rare. This is the situation where the employee says, the employer told me specifically that my protected characteristic or my protected class is the reason they took the action. You know, if the boss said I got fired because I'm a woman, that would be direct evidence of discrimination. In the real world, we just simply don't see cases that that contain direct evidence of discrimination very often. So most frequently what we're talking about is indirect evidence or circumstantial evidence of discrimination, meaning that although the employer didn't tell me point blank that I was being discriminated against, the circumstantial evidence that I have suggests that's the reason why. And when you have indirect evidence of discrimination, that claim is evaluated under what's called the McDonnell-Douglas framework, and we're going to walk through what that looks like. So the first step in the process, the burden is on the employee, and the employee has to prove what's called a prima facie case of discrimination, and that simply means, it's Latin for at first sight, and the concept here is if we haven't heard from the employer, is what the employee is saying enough to to cause the courts to think there might be discrimination going on. So the elements of a prima facie case: number one, the employee is a member of a protected class. Typically, this is not in dispute. We usually agree if the employee is or isn't in that protected class, unless it is retaliation. There are some times where we may disagree about whether the employee has engaged in protected conduct. But for the most part, this is not controverted. The second step is the employee was subjected to an adverse employment action. For the most part, what we're talking about is employees who were fired. So again, we usually don't disagree about whether the employee was fired or not. And the third step is evidence that is sufficient to at least raise an inference of discrimination or retaliation. And an example here, I think a straightforward one, is if the employee goes to their supervisor on Thursday and says, I think I've been discriminated against, here's my concerns, and then on Friday they're fired, the inference from that is that those events are so closely aligned in time that if we don't hear anything else, that would cause you to believe there's cause and effect there, and so that's sufficient to raise an inference. There are a variety of different ways you can do that, but that's just one example. So if the employee meets their initial burden, then the burden shifts to the employer to provide an explanation for the decision that is not prohibited by the statutes. And the idea here is that we're not at the stage where we're looking at, was the decision fair or not, did it make sense or not. We're really just looking at, was the decision prohibited by Title VII or not. So if we say the employee got fired because they were late 10 times when we give them warnings, we're not debating is it fair to fire somebody for being late or not. The employer meets their burden because being late is not a protected class under Title VII.
Okay, I have to go.
David, wait.
No,
Is there no way we can get rid of him?
not without cause, Michael.
I have cause. It is because I hate him.
Okay, so when we talk about employment at Kansas, we're not typically talking about employment that requires cause, because Kansas is an at-will employment state, and that means that employment can be ended by either the employee or the employer for any reason, as long as that it's not something that's prohibited by law. We've talked about what's prohibited by law. When a case gets to me and I'm evaluating an employer's reason for why they did what they did, the things that I look at are still, what was the reason that was provided? Did we have actual cause to terminate the employee? Is there contemporaneous documentation that shows or demonstrates the problem that we say there was? What do the employee's evaluations look like? Are these situations where the employee was repeatedly told that that their job was in jeopardy, or they weren't doing what they were expected to do? What does the handbook or your personnel manual say? Meaning, if the handbook or the personnel manual says we follow progressive discipline very strictly, and it's, first strike is a verbal warning, second strike is a written warning, third strike is you're fired, did we give the employee 3 strikes, or did we just jump to the end? Those are things that we evaluate, because all those things may touch on the credibility of the explanation. And I bring that up now, even though that's not necessarily part of this burden, because as supervisors, or when you're going through an employment decision, these are things that I want to encourage you to focus on, because these are the things that ultimately I think weigh on credibility. So under the third step of McDonnell-Douglas, the court looks at pretext, and the burden shifts back to the employee here. And the key concept is, can the employee present enough evidence to poke holes in the explanation so that the case can go to a jury to decide who to believe here? And pretext just means, is there some inconsistency or some weakness, some flaw with the explanation the employer provided? And ways that employees can establish pretext, an example would be if you have a male and a female employee, they both report to the same supervisors, they both do the same job, and they both were late on Monday to work. If the male employee doesn't get written up and the female employee does, then that's enough that the courts might say, okay, well, the only difference between these two people is gender, so that causes me to think gender was the decision, was the basis for the decision. Other examples, if the employee can present evidence that says that the explanation the employer gave is just not true. They said I did X, but I really didn't do that. And here's the video evidence that shows that, whatever that may be. Evidence that says the employer is ignoring the policies that say that they gave to the employee that said, this is what we're going to do in this situation. That might cause the court to think that if the employer's not following their own policies, maybe the real reason here is discrimination. So ultimately, if a plaintiff can establish pretext, that's when the case gets to a jury to decide. And if a jury finds in the employee's favor, we get to the damages section of this. And this is the important part, I think, to kind of take home why these are so important. So under Title VII, there are a variety of different remedies that a court can impose in a discrimination claim. The first is injunctive relief, meaning a court, if the jury finds in the employee's favor, the court can order the employer to do things. It can order the employer to reinstate the employee, or to adjust their pay to match the other employees. There are things that the court can require the employer to do. The employee can also recover damages, and the types of damages vary, but back pay and front pay are two of the big ones. Back pay, the idea is the employee can recover the difference from what they would have made from the date they got fired through the date of trial, less any wages that they've recovered through a new job. So when you talk about a claim like this, you could be talking about very easily about a period of 4 years. So back pay claim could be 4 years of wages, and so it can add up pretty quickly. Front pay, the idea is if an employee was making $20 an hour at their former employer and they did get a new job, but now they only make $15 an hour, they've got a pay discrepancy, and that's going to happen in perpetuity. So a jury can award them front pay to account for that for the period of time the jury decides is fair. Compensatory damages, we're typically talking about pain and suffering. And the idea here is that, there are a lot of times where somebody getting fired can cause a lot of mental health problems, and a jury can award them damages for that. So when you combine those things, you can get a number that can be pretty big pretty fast. And then the other key takeaway here is attorney's fees. And so when an employee wins a discrimination lawsuit, they're allowed to recover their attorney's fees from the other side. And there's an example here, and that's, let's say that the employee does a good job covering up their damages, and they get a new job the next day and it pays better. So they really haven't lost any money out of the deal. But maybe a jury feels bad for them or agrees that they were discriminated against. They give them $500. The actual award is $500 plus their attorney's fees for the 4 years of work from the day that they got fired until the day they got that verdict. And so we're really talking about hundreds of thousands of dollars potentially, even for a small award. And that's true even if the jury awards $1, it's $1 plus attorney's fees. If they give them anything, they're the prevailing party. And so that's why these are issues that get taken very seriously from the get-go, because even if the damages might seem low, the attorney fee exposure can be very high. And the flip side of that for the employer, and this is a question I get asked every time I get a new case like this, is, well, if I win, can I get my attorney's fees? And the answer is probably not. And the reason employers can't do that is the court has said the standard is for the employer to get it, you have to prove that the lawsuit was frivolous, unreasonable, or groundless, or that you continued it after it became clear that that was the case. And the reason for that is a good one, and that's that there's always going to be some degree of disparity in resources between one employee and an entire organization. And if an employee that has just been fired had to put at risk the potential that they might have to pay hundreds of thousands of dollars for attorney's fees if they don't win their lawsuit, what the result of that would be, you just wouldn't see, people would be too afraid to file these claims. And courts want people to feel comfortable pursuing their rights if they feel they have been discriminated against. So that's why it's tougher for the employer to get their attorney's fees. I've spent a lot of time talking today about the state statutes and the federal statutes, and their protections are generally the same, but the remedies you can recover are not. Under Title VII, we went through the damages. They're different under the Kansas Act Against Discrimination. You can still get back pay, but you don't get attorney's fees, and front pay or emotional distress claims are all capped at $2,000. So from a practical perspective, what this means is that in the real world, we just don't see very many lawsuits actually filed under the state statute. They're all filed under Title VII because the damages you can get are better there. So typically we only see Kansas state statute claims if the employer is somebody that doesn't have 15 employees, but they've got at least 4. Shifting gears, we're going to talk about the fire district's social media policy. This doesn't have anything to do with discrimination, but it's a fairly new policy, and I just want to walk through it with you. So the policy number is 100.42, and this it's a policy that covers all the social media platforms. There are examples listed within the policy. These are the popular ones today, but if a new one comes out tomorrow, it'll still fall under the policy. It applies to just social media platforms at large. And what I've done here is just kind of walk through the do's and don'ts of the policies, but most of these I think are probably you'll find common sense. The idea here is make sure you're using good judgment when you're writing things online. Consider how in relationship to your employment the public would receive the message that you're making online. If you don't want the public to receive your message, consider making your privacy standards so that the public can't see things. Do consider whether your posting could fall under the Kansas Open Records Act, and make sure you understand that ultimately at the end of the day you've got the ability under the First Amendment to engage in private speech on social media. When we talk about the don'ts, I think these are mostly common sense too, but the idea is don't post confidential non-public information on your social media platforms. Don't post things that you don't have permission to post. Don't create accounts that create the impression that they're an official fire district account when they're not. And examples, fire district captain or fire district 123@gmail.com. Even if that's not an official one, somebody reading that might get mistaken. So that's a prohibition under the policy. As is posting or engaging in discussions on social media while on duty. Then there's a difference between that, and the policy does permit you to view social media, just not to engage in communications on social media. All right, so the last thing we've got here is a quiz. This is just true or false. These are going to be pretty straightforward, so I'm going to read it and then just shout out the answer. I think you'd be able to figure most of these out. So number 1, if your intentions are good, your behavior isn't harassment. Right. 2, people who are harassed usually do something to invite it. False. 3, if everyone else thinks that behavior is okay, you should just accept it even if it bothers you. Right. Using slang nicknames that denote a coworker's race, ethnicity, cultural heritage, religion, sex, or age is okay as long as it's done in a joking manner. Right. And again, the idea here is saying just kidding afterwards doesn't make it okay. 5, people whose clothing, personal articles, or hairstyles indicate cultural heritage or religion should just accept that coworkers might make tasteless or offensive comments. Right. 6, both men and women can be harassed. 7, if no one complains, that means you're not offending anyone. Right, and the idea here is that just because you don't know that anyone has complained doesn't mean that nobody has complained. 8, if a victim tells a manager or supervisor they have been harassed, but the manager or supervisor is asked not to report it, they should just respect the wishes of the victim. It's false, and the takeaway here is 2 things. Number 1, what we're talking about is reporting a violation of the law, and the managers, you're really not free to just keep that under your hat. And number 2, if a discrimination lawsuit advances to the point that I'm involved in it and I'm talking to the employee about what happened, I can promise what I'm going to hear is not, well, I did report it, but yeah, I told the manager don't say anything about it. What I'm going to hear at the end of the day is I told my manager about it and they didn't do anything. So you're not free to just keep that under your hat even if the employee asks to. Number 9, one incident of unwelcome harassment cannot support a violation. False. That's the hotel example we talked about. 10, frequently teasing an employee because they are older is not prohibited. And the wording of this is terrible and everybody gives me a blank stare every time. It's false. It is prohibited. It needs to be a reworded question. Number 11, there is no need to investigate a complaint that one employee has texted another employee an offensive photo from a personal device outside of work hours. False. The concept here is that harassment doesn't start and stop with the clock at the end of the day. It can bleed over into the workplace, and something that happens outside the workplace doesn't mean that it doesn't create a severe or a pervasive workplace environment. 12, teasing and crude remarks towards a coworker with a disability can constitute unlawful harassment. True. And the takeaway there is we talked about the ADA is covered under a separate statute, but it is still a protected class. 13, if a manager hears one employee making a remark about another employee's religious observances, they should just wait and see if the victim complains, and if they don't, they should assume that they don't have any objection to the comments. False. The idea here is that we want to make sure that as a manager you're being proactive and you're not waiting for complaints before you take action. If you hear something that you're concerned about, you should proactively investigate it and make sure that there's not an issue. 14, if an employee complains about harassment and an investigation does not prove the allegation to be true, a supervisor or manager may discipline that employee for filing the complaint. False. And again, the idea here is that if discipline could be taken in a situation where we end up with a he said, she said, he said situation, nobody would feel comfortable filing, and that's filing a complaint, and we want to encourage complaints to be filed if there are issues. With that, that's the end of my presentation, and I'm happy to take any questions you have. My contact information is also on the screen if you would prefer to do it that way, but I'm happy to take any questions folks have.